Representative O'Neill of the 69th. You have the floor, sir.
Yes, thank you, Mr. Speaker. I have a few questions for the proponent of the resolution, if I may.
Please proceed, sir.
At the beginning of the conversation, at the explanation of the resolution, and there was a mention made of the Republican budgets and of alternatives that excluded this proposal before us as essentially being illegal, that they would be subject to immediate lawsuits, that the collective bargaining agreements would be broken if we did various kinds of things. And one mention was made of the Rowland case as an example of what would happen, that the impairments of contracts clause would be invoked and under the U.S. Constitution, and there would be an immediate lawsuit if we tried to do some of the things that the Republican House budget at least calls for us to do. And so I would first off ask the proponent if there is any reference in the case of the State Employees Bargaining Agent Coalition versus Rowland referring to the impairments of contracts clause. Through you, Mr. Speaker.
Representative D'Agostino.
Through you, Mr. Speaker. I brought up the Rowland case. Short answer is no.
Excuse me, Mr. Speaker.
I'm sorry.
I thank the member for his answer. There is no reference whatsoever in the Rowland case to the impairment of contracts clause.
I'd love to have been given a chance to finish my response
Yes.
before I was
Representative O'Neill, the
not
representative hadn't finished his answer yet. Representative D'Agostino, please proceed.
Thank you, Mr. Speaker. I brought up the Rowland case to illustrate what can happen when we are challenged by the unions and we can get adverse rulings against us. In that case, I think the liability is over $100 million, if I'm not mistaken. And when you're talking about in this scenario, facing an even higher legal hurdle with the contracts clause, as the good representative who's a very talented lawyer knows, and knows the standards of the U.S. trust case, that if we can't meet those standards, that we're really under the gun, exponentially, when compared to the Rowland case. Thank you, Mr. Speaker.
Representative O'Neill.
Thank you, Mr. Speaker. Again, the Rowland case did not involve, there's no mention whatsoever of the impairment of contracts clause because the Rowland case was all about retaliation by a governor, not the legislature, against state employees by laying them off because the claim was made that the governor did not receive campaign support from the unions involved in the layoffs. And that was the basis of that case. Now, referring to the U.S. trust case, did that case involve a collective bargaining agreement through you, Mr. Speaker?
Representative D'Agostino.
The U.S. trust case did not involve a collective bargaining agreement. It involved the impairment of the state of New York's, I believe, its bonding or city's bonding obligations when compared to New Jersey. And in that case, the Supreme Court, as it does, laid down a standard by which you interpret whether or not a state has properly or not impaired its contract. And it is those standards, that three-pronged standard, that I'm sure the representative is aware of, whether it substantially impairs a contract, whether it is reasonable, and whether it is necessary to an important public policy. That three-pronged test, surrounded by a higher degree of scrutiny, applies whenever a state impairs its contract, just as we've been talking about today. So I appreciate that that particular case did not deal with a collective bargaining agreement, but there is no question, and I'm confident Representative O'Neill would agree with me, no question that that standard is what applies when you analyze a case under Article 1, Section 10.
Representative O'Neill.
Thank you, Mr. Speaker. Is there a case involving a collective bargaining agreement issued by the United States Supreme Court that states that a state has impaired the contract? Through you, Mr. Speaker.
Representative D'Agostino.
Through you, Mr. Speaker, there's not a U.S. Supreme Court case, but there is precedent in this circuit, in particular the Second Circuit.
Representative O'Neill.
And the case involved in the U.S. trust case, which is the basis of this whole area of law, that case involved a bond covenant in the state of New Jersey that was impaired. One of the factors that was not mentioned is foreseeability. That one of the considerations that the court made was that if you couldn't foresee the changes in circumstances, that you had the opportunity then to legislate, because they were referring to an earlier case in which that was exactly what an earlier Supreme Court had held was permissible. So I'd ask the proponent, was it foreseeable in 1996 that the economic conditions facing the state of Connecticut were what they are today? Through you, Mr. Speaker.
Representative D'Agostino.
The standard of, where the standard of foreseeability comes into play is if there's something new. So let's say, and I'm not standing up here, I want to be clear, I'm not standing up here and saying that there might not be some occasion down the road, I think we talked about this, I was responding to an earlier question, if there's another financial crisis that is unforeseen at this time, that arguably would not preclude us from making a unilateral change under this three-pronged standard under U.S. trust. But that's a high hurdle. We couldn't just go in to court 2 years from now and say, yeah, you know what, tax receipts haven't really improved, we want to make a unilateral change to the agreement. That is exactly the type of change that the court found was foreseeable in the Second Circuit case, Association of Surrogates v. New York, 940 F. 2nd 766. So could there be some sort of cataclysmic financial event like we had in 2008 that occurs in 2020? God forbid that happens. Is that an unforeseeable circumstance that arguably, when lumped in with the other three factors, enables you to make a unilateral change to the contract? Maybe. I hope we never get there.
Representative O'Neill.
Thank you, Mr. Speaker. Well, actually, the problem is that we're not talking about 2020 and actions by the legislature then. The Republican budgets are talking about actions by the legislature now in response to the financial conditions which, as the governor has repeatedly described them in the last couple of years, represent a new economic reality that he was not aware of and had not been making plans around when he proposed the budgets that he proposed in 2011, 2013, and 15. What we're dealing with now is an economic reality where Connecticut is lagging far behind the rest of the country in job production or the recovery of the income, where our taxpayers are no longer paying the taxes that they were paying to the tune of hundreds of millions of dollars. And this is well documented by reports issued by the Department of Revenue Services, among many, many others, about the financial conditions of the state of Connecticut today, not in the year 2020. So the question is whether or not today we in the legislature could, for example, continue the de facto wage freeze that exists because the wage contracts have not been negotiated or not at least been ratified, that exist out there and that have left us with a zero wage increase over the last year. That's the situation that we are dealing with right now, not some future problem which some future legislature might try to address by some future legislation. The implication, at least, and perhaps I misunderstood the proponent's comments, seemed to be that because we have collective bargaining agreements that contain language that say that there's, in effect, a continuation, a kind of tail that goes on and on and on after the contract expires, that we are barred from simply not renewing the contract or, as a legislature, from rejecting the contract. So let me ask this, through you, Mr. Speaker. Is the House of Representatives, is the Senate, is the Connecticut General Assembly prohibited by the collective bargaining agreements from rejecting collective bargaining agreements that call for wage increases? Through you, Mr. Speaker.
Representative D'Agostino.
Through you, Mr. Speaker. I don't want to suggest that by operation of these agreements and the extension clauses and 5278A that we are stuck in this perpetual loop of always having to approve and collectively bargain wage increases. That's not what I'm suggesting. What I am saying is that there's a very good legal argument that certainly at least for fiscal year 17 that a union would have going into court to say by virtue of that agreement and the obligation to bargain in good faith that you contractually agreed to extend coupled with the statute that there'd be at the very least a good argument with respect to fiscal year 17. After that, sure. If we want to get rid of collective bargaining for wage and hour, not pension and health care just yet, even I think the representative will acknowledge this as has been stated before, and let's be very clear here. Current SEBAC agreements expires in 2022. That's where the contract clause attaches. You cannot just simply stop collective bargaining, pension, and health care until that contract ends at the very least. But yeah, putting aside the issue of the extension clauses, let's say we win that in court. We go to court, takes a year, we win that. Yes, you can get rid of collective bargaining for wage and hour. If that's the course we're going, as a purely legal matter, the answer is yes. As a practical matter, what happens? The whole deal falls apart. There are no savings in fiscal year 18 and 19. There is no long-term structural change. We wind up in court on a question that, again, I am not sure that we will win. But if that's the path that members of this body want to go down, we can go down it. It's a disastrous one, in my opinion. It's rife with legal risk, in my opinion. But if that's where you want to go, you can go there.
Representative O'Neill.
Thank you, Mr. Speaker. Now, talking about legal opinions, the statement that the legislature or the state generally is bound, at least through 2017, to apparently approve collective bargaining agreements that might contain wage increases, is that a question that was put to the Attorney General, who is the authority giving legal opinions for the state of Connecticut, through you, Mr. Speaker, to the proponent?
Representative D'Agostino.
I do not know if that question was posed to the Attorney General or not. I think what I can tell you with 100% degree of certainty is if this agreement is rejected, and we, as part of that, are obviously rejecting that obligation in the extension agreements, we will wind up in court. And I don't know what the Attorney General will say about our chances, but I can opine about our chances, he can opine about our chances, Representative O'Neill can opine about our chances, but ultimately, we're going to be in court, and a judge is going to tell us what the result is.
Representative O'Neill.
Thank you, Mr. Speaker. Well, the Attorney General is the one whose opinions are binding upon the state government, and certainly are for the administrators, and certainly have great persuasive weight for the legislature. On numerous occasions when we have considered legislation, the opinions of the Attorney General have been brought to our attention and have been sought to try to give us guidance as to what the appropriate course of conduct is and what our chances were in court. Now, what the proponent was talking about at an earlier stage of early on in the conversation was related to the Medicare Advantage program, and the idea that we cannot unilaterally change to the Medicare Advantage program without the risk of litigation. I believe the comment was made to the effect that this would constitute a very substantial change in circumstances, not a mere technicality. So I would ask if the language in the 2009 SEBAC agreement, which is still in existence today, and if I may quote, it's only about 4 lines, under Section 2F, self-insurance, 1, the state may, in its sole discretion, provide health care benefits on an insured or self-insured basis or any appropriate combination of funding bases. Such decisions shall not be appealed or arbitrated in any forum by SEBAC, any constituent union, or state employee. Now, I would ask the proponent if this language is what it says it is, binding on the union and prohibitory of any challenge to the state if, in fact, it were to make a change in its sole discretion of the health care benefits, either insured or to some other appropriate combination of funding bases. Through you, Mr. Speaker.
Representative D'Agostino.
So obviously, anytime there's a change, the benefits have to be the same. So again, if you're changing that structure as you would with Medicare Advantage, that's a substantive change. So I take that kind of change outside of the ambit of that language, and I think it's very clear that a number of retirees might as well. And that's why I go back to the point I made earlier with respect to the litigation risk associated with that. Whether or not that language controls or not, whether or not you can make that argument, that's an argument to make in court. Do we want to take that litigation risk and potentially lose, like in the Rowland case, using that as an example of where we lose? Again, not a contracts clause case. So if we take that risk, it's all on us for the Medicare Advantage change, if we do it unilaterally. But if we collectively bargain for it, we are no longer unilaterally making a change to a contract. It is an agreed upon change. We are thus immune from liability under sovereign immunity because we can't be sued under the contract clause because we're not making a unilateral change to a contract. And the union bears the entire risk for that argument. Again, that I can't underestimate the importance of the litigation risk on a change that both sides of this aisle want. Getting the change we both want, Medicare Advantage, but eliminating the litigation risk for the state of Connecticut.
Representative O'Neill.
Thank you, Mr. Speaker. In the language that I read, is there any reference? There is no reference, I will say this. There is no reference to an exception relating to substantial changes. It's pretty clear that the state may, in its sole discretion, provide health care benefits on an insured or self-insured basis, or any appropriate combination of funding basis. Now, this is language that's in the SEBAC agreement that exists today. If we cannot rely on this language to protect us from future litigation, I do not understand how the language in 2017 SEBAC agreement is going to be any protection either. If this language, which was negotiated in 2009, was part of a collective bargaining agreement that was agreed to by the union, does not protect us, I don't see how any language that's put into any SEBAC agreement is able to protect us. So either this language protects us, or it doesn't. Either this language is a contract that's binding on the union just as much as all the other provisions are binding on the state, or it's not. If any party can at any time choose to look at these agreements and say, well, that's not what I meant, I'm going to go to court and sue you and perhaps get hundreds of millions of dollars in damages, I don't understand what the value of the SEBAC agreements are at all. You can't have it both ways, Mr. Speaker. You can't say that this language doesn't really mean anything, that it's somehow merely technical, and that it doesn't hold up in court, and then turn around and say, but this new language from the 2017 agreement, that's binding. That's something we can really trust. That's going to avoid us getting sued by, apparently, a group of people who might have a reason to want to sue us, the retirees. If this language doesn't protect us, how does the new language protect us? I don't see how it could possibly protect us, Mr. Speaker. To say that all of the changes that the Republican budget seeks to make, which can be implemented by administration, which are pursuant to the SEBAC agreement, where we reject contracts which are called for under our statutes. We have the right to reject contracts. We have the right to reject arbitration agreements if there is insufficient funds. To say that none of that matters, because it's not collectively bargained, and then to say that the collective bargaining agreement that we already have, that doesn't matter either. This has a kind of Alice in Wonderland, topsy-turvy quality to it, Mr. Speaker. That the language means what the unions want it to mean, and when they want it to mean something else, then it means something else. And it doesn't mean anything as far as protecting the rights of the people of the state of Connecticut. It only means something in terms of protecting the rights of the union workers. It cannot be that the legislature does not have the power to do anything significant legally without the permission of the public employee unions. But it sounds to me from the conversation that we have had, from the explanation given by the proponent of the agreement, that that's what it is. The legislature might not as well exist, just the collective bargaining agreement, because it governs everything. It has to be that we have some role to play in the formulation of the state budget. Now, a final comment, Mr. Speaker. The governor proposed that $1.5 billion number at a time when the budget was estimated to be about $3.5 billion out of balance. Then we discovered that it was more than $5 billion out of balance. And the $1.5 billion number to help correct the imbalance never changed. What the Republican budget calls for is, in effect, an adjustment so that the share of the burden for the state employees would rise in proportion to the size of the deficit. The governor called for about a 40% share by the state employees originally, and that's really what we are calling for in our budget. Otherwise, somebody else has to make up those extra $1.5 billion, all of it being borne by taxpayers. This agreement locks us in to an impossible situation. If we approve this agreement, if this agreement becomes law for failure to approve it, then the state of Connecticut is locked in for the next 10 years on the SEBAC side of things, and I'm not quite sure how it is that 2017 we are obligated by the tail ends of the contract, by the continuation agreements, but somehow that's not going to be a problem in 2019 or 2020. Either we are handcuffed by the existing wage agreements or we're not. It cannot be that we're handcuffed this year because we're considering this matter today, but we're not handcuffed 3 years from now when we are being given the hope that maybe we could make some changes. There is a complete contradiction, in my opinion, in the presentation of this SEBAC agreement as to what its impact is and what our legal requirements are right now under the existing agreement and what our legal rights are right now. Seems like we have no rights, we only have obligations to the unions. That cannot be. This agreement should be rejected. The governor should go back to the negotiating table, and he should get a better agreement for us that where the share of the burden is proportional to the size of the budget in the same percentage that it was originally. He asked the unions for about 40% of the budget deficit to be borne by the unions. He should go back and ask for the 40% of the budget deficit to be borne by the unions. Thank you, Mr. Speaker.